May it please the Court, Chief Justice, and the members of the Court, it's M. Zigalala. I appear for the Economic Freedom Fighters in case number CCT 35 of 2024.
Thank you, Ms. Zigalala. Okay. Today, sorry, is there another one? Oh, sorry, I didn't see you. How could I not see you?
Justices, as Mrs. S.M. Pedro Bila from State Attorney Johannesburg, I appear on behalf of the first and second respondents in this matter, as the Court pleases.
Thank you.
Thanks.
Is there another appearance?
Chief Justice, Justices, my name is Anati Kenam, and I appear on behalf of the third respondent. Thank you.
Thank you, Mr. Kenam. Today, is there another appearance? How many are you?
My apologies, Chief Justice. The name is Ntokozo Kwabe, and from the Johannesburg Bar, and I appear for the fourth respondent.
All right, everyone is represented. Is that everyone? Okay, thank you. Today, the Constitutional Court hands down judgment in an application brought in terms of Section 167, subsection 4E of the Constitution by the Economic Freedom Fighters, the EFF, and the African Transformation Movement, the ATM, to whom I shall collectively refer as the applicants. I start by taking full responsibility for the delay in producing this judgment concerning an extremely difficult matter of great national importance. And I tender my sincere apology to the parties, my colleagues, and fellow South Africans for the inconvenience it has caused. The applicants seek an order declaring as unlawful and irrational a decision of the National Assembly taken on 13 December 2022 to not adopt the report of the independent panel, hereinafter referred to as the report, and refer it to the Impeachment Committee. This decision was in the context of an impeachment inquiry into alleged violations of the law and the Constitution and alleged serious misconduct by the President of the Republic of South Africa, Mr. Matamela Cyril Ramaphosa, in connection with events that occurred at his private farm, the Palapala Wildlife Game Farm. The applicants further seek a declaratory order that Rule 129I of the Rules of the National Assembly, which I will call the NA Rules, is inconsistent with the Constitution and invalid as it permits Parliament to avoid fulfilling its obligations to hold the President accountable. The respondents who oppose the matter are the Speaker of the National Assembly and the National Assembly, who I refer to collectively as Parliament, the President, and the African National Congress, the ANC. The other respondents are all the other political parties represented in the National Assembly, and they did not oppose the application. The matter emanates from the alleged storage and theft of a large sum of foreign currency from Palapala in February 2020. On 1 June 2022, Mr. Arthur Fraser, the former National Commissioner for the Department of Correctional Services, issued a media statement announcing that he'd laid criminal charges against the President and other parties in relation to stolen foreign currency that was illegally brought to South Africa by the President's advisor on the President's behalf. He claimed that the money was not declared to the South African Revenue Service or the South African Reserve Bank, but was transferred and stored in a couch at Palapala. Mr. Fraser also alleged that the President had sought assistance from his Namibian counterpart, President Hage Geingob, in the arrest of the suspected mastermind of the theft, who was allegedly hiding in Namibia. The President denied Mr. Fraser's allegations and insisted that the money was the proceeds of a cash sale of 20 buffalo made to a Sudanese businessman, a Mr. Mustafa Hazim, in December 2019. In July 2022, the then president of the ATM submitted a notice of motion to the Speaker in terms of Section 89, subsection 1 of the Constitution and the NA rules, requesting the National Assembly to initiate an inquiry into the removal of the President from office on the grounds that he had committed a serious violation of the Constitution and the law and serious misconduct. The motion stated that the President had violated A, provisions of the Constitution which prohibit members of the Cabinet from undertaking any other paid work, in that the President had publicly declared himself a farmer in the cattle and game business who buys and sells animals. B, provisions of the Prevention and Combating of Corrupt Activities Act 12 of 2004, hereafter referred to as PRECA, read with the South African Police Service Amendment Act 20 of 2012, in that the President had failed to report the housebreaking and theft to the police. C, provisions of the Constitution in terms of which members of Cabinet may not expose themselves to situations involving the risk of a conflict between their official responsibilities and private interests, because the President asked General Rode, the head of the Presidential Protection Unit of the South African Police Service, to investigate the theft, despite General Rode lacking the authority to investigate security issues at Palapala. And D, provisions of the Constitution in terms of which members of Cabinet may not act in a way that is inconsistent with their office, because his unlawful instructions to General Rode showed dishonesty and constituted misconduct and unlawfulness. The Speaker appointed an independent panel to conduct an investigation into these allegations. The independent panel subsequently submitted its report, in which it concluded that the evidence before it prima facie established that the President may have committed a serious violation of the Constitution and PRECA. On 13 December 2022, the report came before the National Assembly for consideration and voting on the question whether to refer the matter to the Impeachment Committee for further consideration. The National Assembly voted by a majority against referring the motion to the Impeachment Committee. Before this court, the applicants contend that this court has exclusive jurisdiction to decide the matter, as it concerns the National Assembly's failure to fulfill its obligation to hold the President to account. Under Section 167, subsection 4E of the Constitution, only the Constitutional Court may decide that Parliament or the President have failed to fulfill a constitutional obligation. The applicants challenged the vote of the National Assembly declining to refer the motion to an impeachment committee as irrational and unlawful. They also challenged Rule 129I as a breach of the National Assembly's constitutional obligation under Section 89 of the Constitution to put in place an effective mechanism to hold the President accountable in terms of that section. The President, supported by the ANC, opposes the application on several grounds, including that the matter is, in substance, a rationality review against the National Assembly's decision, which was unreasonably delayed without explanation, and that the matter has become moot. They also submit that this case does not engage the exclusive jurisdiction of this court, and that no basis has been established for direct access. Parliament concedes that the relief sought by the applicants falls within this court's exclusive jurisdiction, but disputes the contention that Rule 129I is unconstitutional. It also argues that because of the delay in launching the application, conducting a Section 89 inquiry before the Impeachment Committee has become legally impossible. Against this factual backdrop, this court was tasked with determining the following. One, whether this court has exclusive jurisdiction to entertain the matter, and if not, whether direct access is warranted. Two, whether procedural issues bar consideration of the merits. Three, if not, whether Rule 129I and the National Assembly's vote declining referral to the Impeachment Committee are consistent with the Constitution, and 4, what remedy is just and equitable. 3 separate judgments have been produced in this matter. The first judgment is written by myself and concurred in by Acting Deputy Chief Justice Madlanga, Justice Theron, and Justice Rogers. On exclusive jurisdiction, it finds that the Constitution imposes clear and specific obligations on the National Assembly to ensure executive accountability, to put in place effective mechanisms to maintain oversight of the exercise of national executive authority, and to take appropriate action in holding the President accountable. It finds that the challenge to Rule 129I implicates the obligation to put effective mechanisms in place, and that the challenge to the National Assembly's vote implicates the obligation to hold members of the executive accountable and to take appropriate action against the President. It holds that the fact that the applicant relied on rationality and legality review grounds does not remove it from this court's exclusive jurisdiction. Where a constitutional obligation is implicated, this court has exclusive jurisdiction to hear the matter. The respondents raised other procedural issues which they argue should dispose of the matter, such as delay and mootness. This application was brought nearly 14 months after the National Assembly took its decision in December 2022. This court has previously held that it must be determined first whether delay is unreasonable, and second, whether the interests of justice require that the delay be overlooked. The first judgment finds that the substantial delay, which was not explained, is unreasonable. However, it finds that several factors favor overlooking the delay, including the fact that there is no prejudice to any of the respondents, that this court's ability to adjudicate the matter has not been impaired by the delay, and the tremendous importance of the matter. The first judgment finds that there is a proper basis to overlook the delay in all the circumstances. The question of mootness can relate only to the EFF's attack on the National Assembly's decision on 13 December 2022. Parliament and the ANC argue that the terms of the 6th Parliament has expired, and so the relief sought by the EFF has become moot, as a Section 89 inquiry is now legally impossible. The first judgment finds that nothing precludes the adjudication of the challenge to the rule, as challenges to existing and fully operational statutory provisions can never be considered moot. Functionaries are generally held to enduring legal obligations attaching to their official capacities, despite the succession of incumbents or change in their ranks. Additionally, the process of an impeachment inquiry could take many months. If impeachment proceedings that started in one parliament could not be carried over to the next, it would be practically impossible to initiate and finalize impeachment proceedings. For these reasons, amongst others, the first judgment finds that the challenge to the impugned decision of the National Assembly is not moot. I turn to the merits of the matter. Section 89, subsection 1 of the Constitution contemplates a two-stage process for impeachment: a preliminary inquiry to determine whether a listed ground exists, followed by a decision by the National Assembly on whether or not to remove the President from office. This court has already held that the making of specially tailored rules is obligatory to regulate the process of impeachment under Section 89, subsection 1. The National Assembly did this in passing Rules 129A to 29Q. However, the rules it passes must be effective in ensuring that appropriate action may be taken to hold the President accountable. Rule 129I permits the National Assembly to terminate the impeachment process at a preliminary stage before a full inquiry can be conducted into whether a ground listed in Section 89, subsection 1 exists. This has the effect of foreclosing full engagement with the merits of the motion, stifling informed debate and undermining the values of accountability and transparency that must inform the National Assembly's processes. It is not sufficient for the National Assembly to proceed directly from receipt of an independent panel report to a vote and thereby suppress an impeachment motion that discloses prima facie the existence of a ground under Section 89, subsection 1. The National Assembly is required to do more than merely table, debate, and vote on such a substantiated motion. The rule is therefore inconsistent with the Constitution and invalid. The first judgment finds that the vote must follow in the rule's footsteps. Legally, the vote and the rule are on the same constitutional footing, and so the one must follow the other. The vote was influenced by material error of law. It is therefore inconsistent with the Constitution and must accordingly fall. In respect of a just and equitable remedy, the first judgment finds that in this matter, a limited severance coupled with reading in is necessary to correct the rule in compliance with the Constitution, to remain in effect until the National Assembly corrects the defect in the affected rule. It would also be appropriate to refer the report to the impeachment committee consistent with the reading in remedy ordered. The first judgment finds that the EFF has been successful and should be awarded its costs, though only the cost of 2, not 3 counsel, as it asked. The ATM did not seek costs. The second judgment, written by my brother Kolapen J, with Matopo and Chike JJ and Sikobin AJ concurring, takes a different approach to the issues of exclusive jurisdiction and the constitutionality of Rule 129I. The second judgment locates its assessment of the issues by identifying the carefully structured interconnectedness and balancing of majoritarian and counter-majoritarian provisions in the Constitution. In doing so, it explores the disenfranchisement of the vast majority of South Africans prior to 1994 and recognizes that majoritarian measures are often democracy-enhancing and may, where they appear in the Constitution, represent a deliberate location of political power by the drafters of the Constitution. It is a choice courts are obliged to respect. In support of this stance, the second judgment cites this court's judgment in ex parte chairperson of the Constitutional Assembly in re certification of the Constitution of the Republic of South Africa, in which it held that this court has no power, no mandate, and no right to express any view on the political choices made by the Constitutional Assembly in drafting the new text. On the basis of these principles, the second judgment agrees that this court's exclusive jurisdiction over the challenge to Rule 129I is engaged, but for different reasons, different to those advanced in the first judgment. Relying on this court's decision in EFF2, the 2017 judgment, the second judgment finds that the only obligation imposed on the National Assembly by Section 89 is the responsibility to develop rules to facilitate the removal of the president. However, it notes that any decision the National Assembly takes in this respect falls wholly within its discretion. It can hardly be sustainable to suggest then, says the second judgment, that a discretionary power creates a constitutional obligation to hold the president accountable, as is found in the first judgment. In fortifying this finding, The second judgment distinguishes Section 89 from specific provisions of the Constitution, such as Sections 42 subsection 3 and 91 subsection 2, that expressly create mutual accountability obligations on the part of the President and the National Assembly. On the challenge to the rule, the second judgment aligns itself with EFF2 in finding that the only obligation Section 89 creates is for the National Assembly to put in place rules to facilitate the removal of the President should it elect to do so. It is against this objective that Rule 129I must be assessed. The second judgment then identifies Section 89 as a deliberately majoritarian provision which vests a permissive power to impeach the President in the National Assembly alone. It concludes that in line with tried principles of the separation of powers and constitutional supremacy, this court is obligated to respect the powers Section 89 bestows on the National Assembly. On this basis, the second judgment finds that Rule 129I is not unconstitutional in that it properly operationalizes the permissive power of the National Assembly to remove the President. With respect to the challenge to the vote, the second judgment, unlike the first, concludes that this court does not enjoy exclusive jurisdiction over this challenge for two reasons. First, having concluded that Section 89 does not create a constitutional obligation to hold the President to account, it finds that the failure to discharge that alleged obligation cannot be relied upon to establish this court's exclusive jurisdiction. Second, it concludes that the true bone of the applicant's argument and the discomfort expressed in the first and third judgments in fact lies in the manner in which the National Assembly voted and not with the rule itself. Relying on this court's judgment in Van Rooyen versus the State, which draws a clear distinction between the adequacy of a rule and the exercise of power under a rule, directing that the appropriate remedy for the improper exercise of power lies in reviewing the exercise of such power rather than in the invalidation of the rule. Finally, and in response to the first and third judgments, the second judgment outlines what it believes to be two fundamental and insurmountable contradictions in the outcomes arrived at by those judgments. First, it cannot be that a vote taken in terms of an unlawful rule is automatically impugned by virtue of the unlawfulness of the rule. This very point is illustrated by the first and the third judgments. Despite the reasons posited for the unconstitutionality of the rule in each of those decisions, the rule in its current form may still yield lawful votes by the National Assembly. This would occur, for example, in the circumstances where the National Assembly accepts a positive recommendation of the panel and the matter proceeds to the impeachment committee, or where it refuses to accept a negative recommendation of the panel and the matter proceeds to the impeachment committee despite the panel's finding. With this in mind, the second judgment takes the view that whilst an act taken in terms of an unlawful empowering provision may be invalidated, where the empowering provision is declared unlawful, this should not be considered automatic. In this context, it has already shown that the rule is capable of producing valid votes by the National Assembly, despite the invalidation of the rule. Furthermore, the same outcome as a declaration of invalidity, as ordered in the first and third judgments, may be achieved through a rationality challenge to the vote, raising the inevitable question why unnecessarily impugn the rule when the same outcome may be achieved through a challenge to the vote. Second, the order proposed by the first and third judgments would oblige the National Assembly to accept a positive recommendation from the panel, but would allow it the discretion to overturn a negative recommendation from the panel if need be. There can be no conceivable reason for this contrasting approach to positive and negative recommendations from the panel, It recognizes the validity of the National Assembly's power to grapple with a negative recommendation from the panel, whilst denying it the exercise of such power when a positive recommendation is made. This contradiction lends support to the conclusion that the source of the first and second judgment's discomfort can be addressed through a challenge to the vote without impugning the rule. On these bases, the second judgment would have found exclusive jurisdiction in the challenge to the rule, but would have dismissed that challenge as Rule 129I passes constitutional muster. The third judgment, penned by Justice Majid with Justice Mhlanhla and Acting Justice Tolmei concurring, agrees with the first and second judgment's reasoning and findings on exclusive jurisdiction with respect to the rule. That is, that the court has exclusive jurisdiction to consider its constitutionality. The third judgment, like the first judgment, finds that Rule 129I is unconstitutional, but on a different basis. The third judgment holds that Rule 129I deprives the full National Assembly of the opportunity to vote on the existence of a ground for impeachment and precludes a full ventilation of the facts that inform the vote. The National Assembly is constitutionally obliged to determine whether the President has committed conduct falling within Section 89, subsection 1, and that determination must be rational, evidence-based, and attributable to the National Assembly as the ultimate decision maker. In EFF 2, this court interpreted Section 89, subsection 1 as entailing a structured two-stage process. First, there must be an investigative and evaluative stage in which the relevant facts are gathered and assessed. Second, there must be a decision stage in which the National Assembly determines whether the jurisdictional facts for removal exist, and if so, whether to remove the President. While the investigative and evaluative tasks may be performed by committees or through other mechanisms, the constitutional obligation to determine whether a ground for removal exists rests solely with the National Assembly. The third judgment holds that Rule 129I inserts a third antecedent step prior to Rule 129J. Once a motion is initiated and referred to a panel, the panel conducts a preliminary assessment and reports on whether sufficient evidence for an inquiry exists. Thereafter, the National Assembly is required to vote, not on whether a Section 89 ground exists, nor or whether the President should be removed. That is the two steps envisaged in EFF 2, but rather on whether a Section 89 inquiry should proceed further. If the National Assembly resolves not to proceed, the process terminates at that point, and the Section 89, subsection 1 impeachment motion is never voted on. The National Assembly never gets to consider either the first or the second stage. This is a fatal flaw and a violation of the Constitution. The impugned rule as it stands requires the National Assembly to first step back and decide whether to engage in that process at all, and permits the process to be halted before it even begins. Even if the National Assembly were to consider the panel's report, its vote at the Rule 129I stage remains a procedural decision rather than a substantive constitutional determination. It is not a finding about whether the President has committed a serious violation or misconduct, nor does it pronounce on his or her inability to perform the functions of office. The fact that the National Assembly never applies its mind to the Section 89, subsection 1 question is further underscored by Rule 129M, which takes place at the impeachment committee stage. That stage is never reached if the National Assembly decides not to proceed beyond the panel. Rule 129M provides that once the National Assembly has resolved to proceed, the impeachment committee must establish the veracity and, where required, the seriousness of the charges. This necessarily means that the National Assembly's consideration under Rule 129I is not related to the veracity of the report. The National Assembly is therefore expected by the impugned rule to make a decision in the absence of the information that the Constitution requires for that decision. The result is that the preliminary stage does not facilitate the constitutional inquiry, it displaces it. This also undermines the majoritarian design of Section 89, subsection 1. The Constitution envisages that the decisive judgment whether to remove the President is to be taken by a special majority of the National Assembly, that is the 2/3 of the National Assembly, after engagement with the merits. But because Rule 129I allows the process to be halted at the threshold, the National Assembly is never called upon to make that value judgment. In summary, Rule 129I introduces an impermissible preliminary step that allows the National Assembly to decide whether to decide. In addition to the reasoning above, the third judgment holds that the Section 89 power cannot be exercised without a factual foundation. In order for a Section 89 subsection 1 ground to be established, there must be a finding that is partly factual. Is their conduct capable of meeting such a ground? And partly normative. Does the conduct meet the level of seriousness envisaged by that section? That vote, as the rules stand, relates neither to the factual finding nor the normative determination of whether a listed ground exists. The third judgment further holds that this state of affairs results in a lack of transparency and openness in the process. The panel conducts its work on a limited written record, and the more rigorous processes of testing evidence, assessing veracity, and evaluating seriousness are reserved for the impeachment committee stage. If the process is halted before that stage is reached, the National Assembly's decision is taken without the benefit of a full and public exposition of the issues. The absence of transparency has consequences beyond the immediate decision. Where evidence is properly tested and placed in the public domain, it equips the electorate with information that bears directly on the exercise of political choice, including at the next election. It also enhances the conditions under which members of the National Assembly themselves deliberate. This does not mean that the National Assembly is obliged to reach any particular outcome, nor does it diminish its authority to decide whether to remove the President. It means only that the process through which that authority is exercised must be sufficiently open to allow for meaningful public scrutiny of the issues and the decision. The third judgment concludes that Rule 129I is unconstitutional and must be set aside. It further holds that the National Assembly's vote must likewise be set aside because it was taken under an invalid rule that prevented the National Assembly from properly determining whether a ground for impeachment existed. The vote, therefore, lacked a lawful foundation. Applying the decision of this court in Genesis Medical Schemes versus Register of Medical Schemes, the third judgment holds that once the rule is set aside, the vote taken under it cannot stand. The conclusion is this: the effect of the three judgments is as follows. This court, A, unanimously finds that it has exclusive jurisdiction in respect of the challenge to the validity of Rule 129I. B, by a majority, finds that it does not have exclusive jurisdiction in respect of the challenge to the NA vote. C, by a majority, concludes that Rule 129I is inconsistent with the Constitution and invalid. D, by a majority, concludes that the NA vote is inconsistent with the Constitution and invalid, and E, by a majority, concludes that the report must be referred to the Impeachment Committee. As such, the following order is made. 1, this court has exclusive jurisdiction to hear the application with respect to the challenge to Rule 129I. 2, it is declared that Rule 129I of the 9th edition of the Rules of the National Assembly, the NA rules, is inconsistent with the Constitution, invalid, and it is set aside. 3, pending any amendment, Rule 129I of the NA rules shall read as follows, open quote, Rule 129I, heading Consideration and Referral of Panel Report. 1, once the panel has reported, the Speaker must inform the Assembly of the report. 2, the President must be provided with a copy of the report forthwith. 3, in the event the panel concludes that sufficient evidence exists as contemplated in Rule 129G, the matter must be referred to the Impeachment Committee established by this rule or by the National Assembly rules for that purpose. 4, in the event the panel concludes that sufficient evidence does not exist as contemplated in Rule 129G, the Speaker must schedule the report for consideration by the Assembly, and in the event the Assembly nonetheless resolves that a Section 89, subsection 1 inquiry be proceeded with, the matter must be referred to the Impeachment Committee established by this rule or by the National Assembly rules for that purpose. 4, the severance and reading in paragraph 3 of this order shall apply subject to any amendment by the National Assembly. 5, pending any amendment of the NA rules to the extent that any of the other NA rules are by implication affected by the reading in paragraph 3 of this order, those rules shall be read consistently with paragraph 3 of this order, mutatis mutandis. 6, it is declared that the vote of the National Assembly taken on 13 December 2022, declining to refer the report of the independent panel to an impeachment committee as envisaged in the NA rules, is inconsistent with the Constitution, invalid, and it is set aside. 7, the report of the independent panel is referred to the impeachment committee established in terms of the NA rules. 8, the first to fourth respondents are ordered to pay the cost of the first applicant, including cost of to counsel where applicable. I hand down the judgment. Court adjourns.